Edward Snowden, who was involved in the intelligence activities of the U.S. federal government through his work for the National Security Agency and the Central Intelligence Agency, blew the whistle on the United States collection of information at the expense of the privacy of ordinary citizens around the world. He exposed this injustice even though he risked his freedom in doing so. According to Snowden, privacy is the foundation of an individual's fundamental human rights and of freedom itself. Even the Constitution of Japan stipulates that the right to privacy is an aspect of the right to the pursuit of happiness. But to what extent is our privacy actually protected? The right to privacy, which is closely linked to a person's freedom and happiness, is the right to act freely without fear that, to one's detriment, one is being monitored, spoken about, or judged. If, for example, telephone calls or internet communications are intercepted by state agencies without permission, or if news reporters try to force their way into someone's home to conduct an interview, the individual's privacy is immediately compromised, and their freedom and happiness are threatened. It's true there may be situations in which it's necessary for the state to gather certain information to maintain security. The mass media is also free to gather information and report it. But it must be emphasized that reporting to the public the real names and addresses of suspects, who are ordinary citizens, as well as barging into the homes and workplaces of the families of perpetrators, victims, and bereaved families, goes beyond the scope of freedom of speech and news gathering. Rather, such mass media practices aren't just excessive, but criminal. In Japan, the age of majority was reduced from 20 to 18 in April 2022. 18 and 19-year-olds, who were once protected by the juvenile law, may have their real names reported if they are arrested and charged with a criminal offense. Even in the case of a murder or some other serious crime, most people want to know the name of the suspect simply out of idle curiosity. In the long run, this will destroy the chance of rehabilitating the offender and obstruct the path to compensation for the damage caused. It's doubtful whether the majority of the public has acquired media literacy. For example, without strong public awareness of the ironclad rule of the presumption of innocence, the reporting of real names can do only harm. The police, in particular, put on a ridiculous show by parading ordinary citizens one after another and acting triumphantly like conquering heroes in order to divert attention from their own misconduct. To weaken the public's interest in repeated police scandals, ordinary citizens suspected of crimes are exploited as the ideal tool, regardless of the seriousness of their crimes. The mass media excessively criticize those whose values or attitudes they feel don't align with their own. They force people to resign from their jobs, search for culprits without legitimate authority, and arbitrarily judge those they find. The rationale that real name reporting is only done because viewers want it, so the mass media and police aren't responsible, is completely untenable. If the mass media really want to follow that logic, they should be reporting the real names of all suspects. It's the diversionary announcements by the police and the unbalanced reports by the mass media that are interfering with the public's right to know the truth. Online news articles reporting real names are also called digital tattoos, in that they remain in the public sphere semi-permanently, drawing attention to the people they name. Lawsuits seeking to remove such digital tattoos have been filed in Japan. In 2012, a man was arrested for surreptitiously entering the changing room of a women's bathhouse at a Japanese inn and was charged with trespassing. Subsequently, the URL of an article reporting the incident was posted on Twitter. In 2019, the Tokyo District Court, as court of first instance, ordered removal of the tweet, but in 2020, the court of second instance reversed that decision, allowing the tweet to remain. The deletion of the tweet was refused on the grounds that the Peeping Tom incident wasn't a minor crime and that access to the content linked to in the tweet was in the public interest. On June 24, 2022, 10 years after the incident, the deletion of the tweet about the case was approved on the grounds that not making it public was more beneficial than allowing it to be viewed. All four judges agreed. Other countries besides Japan are taking serious steps to address libel on the Internet and protect individual rights. In Europe, companies operating social media platforms are required by law to immediately delete posts found to contain any degree of defamation. Some countries impose hefty fines on companies that fail to meet this requirement. The EU General Data Protection Regulations Article 17, which concerns the safeguarding of personal data, includes the right to erasure, commonly referred to as the right to be forgotten. This means that someone who has committed an offense has the right to be forgotten by the public, and for this reason, the relevant data should be deleted. In March 2020, around 30 senior male police officers responsible for guarding the Imperial Palace were punished after it was discovered that not only had the principal and instructors of the police academy repeatedly consumed alcohol with new guards who were underage, but that guards had been involved in voyeuristic behavior. All of them were, of course, reported without their names being revealed. For the right to privacy to be protected in Japan, the following are essential. The right to privacy should be clearly stated in laws and regulations. The scope of freedom of the press should be reconsidered and the right to be forgotten should be established. All international norms should be complied with. Thanks for watching.